Hello, my name is Randall Borden. I'm an attorney in Virginia and Maryland, and I'm here to talk about ways to behave in court during a contested custody case. So that will probably be the first time that the judge sees you. Certainly, there was a lot of activity prior to the final trial date, like motions and things like that. The motions are usually handled lawyer to lawyer, with only the two lawyers being in the courtroom. So the trial will be a chance for the judge to observe you over a long period of time. It could be a few hours or a few days, and the judge's clerk and the deputy, including how you act outside in the hallway, outside the courtroom, will be watching you and reporting back to the judge. Might be directly, might be shaking their head or nodding or a raised eyebrow. But you're really on display at a trial, so you need to show up on time, show up a little bit earlier. I always tell my clients to go there beforehand in order to see what it's like, certainly to find a place to park. If you can't park in my parking lot, then you'll need to locate the parking for the courthouse. Obviously, show up early, make sure that your meter is fed, or you make other arrangements. Plan to be there all day. Most of the courthouses will have a little cafeteria, something like that. Obviously, take care of things before you get there. Go to the bathroom, put your makeup on, make sure your tie is straight. Make sure you know where the courthouse is, where to park, how to get into the courthouse. Security is always tight and will be a little unpredictable sometimes, whether you have to leave your cell phone camera in the car, whether you can take in a pocket knife or whatnot. Probably you'd have to leave that in the car, but things like even staplers or scissors, they don't let you take them into the courthouse. So you get past security, you ask the deputy where your courtroom is, you go there. If possible, go inside, check things out. What you'll typically have, the layout is the plaintiff sits on one side, the defendant sits on the other. The rule of thumb is the plaintiff will sit closest to the jury. So if you see a jury box on one side of the courtroom or the other, that's normally where the plaintiff would sit. There's usually a table, and a podium in the middle with a microphone, and the judge, of course, sits in the back up on the dais. So then you want to make sure that you have whatever you're going to need in the courtroom. Many times they do supply like a glass of water, whether you can drink bottled water in the courtroom. We'd want to check with a deputy first. There's some general rules, but some rules are specific to each courtroom. So then you dress appropriately. I should say, at least don't dress inappropriately. So it would be nice if you could wear a suit and tie or a jacket and tie, and women would certainly want to wear a dress or a nice pantsuit. Kind of think about what you'd wear going to church or going to synagogue or going to a temple. So you would want to dress conservative, nothing flashy, no strange haircut or anything like that. If you have that, try to tone it down. If you have tattoos, try to cover those up. They're not appreciated and may give the wrong impression. So you'd want to have a good behavior, stay calm. You're going to be insulted by opposing counsel. Don't react. Spouse knows every way to trigger you. That's going to be a strategy in court, is to get you to misbehave, to go off, to start to cry, to start to yell. There are lawyers who know how to do that, do it deliberately. Obviously, it'll be my job to jump up and object to any kind of a strategy like that. So, but it will happen. Be prepared for it. Your lawyer should meet with you ahead of time and go over what your testimony is going to be, what it is that you should be saying. Even if you have something wrong, make sure you tell your attorney. The attorney can deal with that straight off. I mean, it's called inoculation. If you have an arrest in your past or alcohol, drugs, bring that up yourself and deal with it and explain it away. And that kind of removes a weapon that the other side might use against you or might try to shock the judge or surprise you with. You're going to be observed before the hearing starts, during the hearing, even when you're sitting at the desk, sitting at the table while the other side is testifying. The judge is watching you, the judge's clerk, certainly the deputies are watching. That's their job, everything all the time. Then you'll want to be prepared. Certainly, I usually give my clients writing tablet, pen, paper. They can write me notes. Don't react to what the witness is saying or the other party is saying. Again, you want to write that on a piece of paper and show it to your lawyer and get the message across that way. And make sure you write big so the lawyer can see it from, the other side of the table. Then those are the points that you want to get across. Just typically the witness would testify and then the other lawyer gets to ask questions. So that's called direct testimony. And then cross-examination would be questioning by the other attorney. So you're going to get your shot in. You're going to get the chance to help your attorney ask the right questions, either on direct, if it's your witness, or if you are testifying, and then help your attorney ask the right questions on cross-examination, whether it's the other party or whether it's a witness for the other party. You want to make sure that if the other party is a liar, you want to make sure that the judge knows that. And that on cross-examination, you can bring out things they wrote before, text messages, whatever. And then again, the same thing with witnesses. If they're biased, if they're the sister of the other party, you certainly want the judge to know that. If they're benefiting in some way financially, like they're the paid babysitter, of course they're going to say what they're paid to say, and just make sure that that comes out. The judge knows that they're being paid. They win the custody fight, they'll keep getting paid. They're the babysitter that's being paid under the table. If that party gets custody, then the money will continue going under the table. So that's the kind of thing that you want to bring out, that they cheat on their taxes. Are they a licensed daycare provider? So again, don't act up in court. Help your lawyer understand, and then you can get these people really with a strong attack on cross-examination. So that's the way you want to channel your energy. Don't jump up out of your seat, don't roll your eyes, don't grimace, don't throw yourself back, certainly don't bang on the table, that kind of thing. So again, just assume that you're being observed all the time. And frankly, most of the courtrooms do have cameras in them, and those are monitored at least by the security people in most courtrooms now. So you are literally being observed all the time. And the hallway also, certainly you go in the hall, you can relax, but don't start yelling, don't start waving your hands, that kind of thing. Again, there's a procedure in court to get a bad party or a bad witness, and help your lawyer do that. So that would be the way to channel your energy. Typically, custody trials go very long. And again, as I said, there's usually a cafeteria or a little cafe in the courthouse. So you'll probably be down there with the other side, with their witnesses, sometimes they bring the children, sometimes the other side will try to start a fight. On the opposite, sometimes I've settled cases in the cafeteria, or in the hallway, and it's very common. So if that seems like a possibility, again, we can tell the judge that, hey, the parties are talking a settlement. Could you give us, a few more minutes in the hallway? Maybe we could come up with something, and the judges are always happy to do that. So, don't assume that the other side is going to be there as your enemy, or don't assume that, other witnesses are going to be your friend. You're typically not supposed to talk about what happens in the courtroom. So don't try to grill the other side. The other lawyer will bring that up. Any misbehavior that you do in the hallway, in the bathroom, in the cafeteria, in the parking lot, figure that it'll get back to the judge one way or the other. Obviously, don't attack anyone in the hallway. That's happened. That's very bad for your custody case, and you'll usually end up with supervised visitation instead of as your visitation, rather than getting custody. You want to show, and certainly your demeanor when you're asked on the stand, when you're asked the difficult questions. What did you feed your child today for breakfast? Is that typical every day, or don't you usually just feed them an energy drink and a candy bar and send them off to school? Isn't that the usual? And said, no, I pay attention to what a child needs for breakfast. We get orange juice, we get some stuffed breads, some meat, so that kind of thing. They'll ask you, what did you feed your child today? What are the child's grades? When was the last time you went to school? Again, your lawyer should be preparing you for all of these difficult questions. And of course, if the other party has cut you out, you can say, well, the school won't talk to me, the teacher won't return my calls or respond to my email. So then I went to the principal. I went to other parents. I mean, again, you should be prepared for those questions. Don't just start yelling at your spouse for what they did or didn't do. You want to have a controlled, rational response to any difficult question. And again, you might be the bad parent. So the process of inoculation, might be, well, I used to drink too much, but now I'm in AA. I've been going there for 3 years. I've gotten to my different levels of AA. I have sponsors here to testify. I've been sober and dry. It was a difficult time, but I got through it. And now, I want to resume a normal life. And that would start off with being part of my child's life, hopefully more and more as the years go by. I think I have a lot to offer my child in spite of or because of my prior life. I can point the child in the right direction. So again, even if you've got something negative, and if you do, tell your lawyer, like I said, so the lawyer can be prepared for it. You don't want a surprise to come up on the stand. And like I said, it's called inoculation. You bring it up first, and then you can frame it. You can put it in perspective for the judge. As I said, the example of a drinking problem in the past or a drug problem, you certainly want to have an attendance at AA, attendance at NA. Bring that up. You could bring your certificates or your cards, or your tokens showing you've moved up the levels, have your sponsor there as a witness to testify. So that would be, again, something that you don't want to get angry. Don't let them stick it to you. But again, if you tell your lawyer far enough ahead of time, your lawyer can deal with that. Other things that come up, of course, if the children are there in the courtroom, do not talk to them about the case. Do not ask them what, the other parent is going to say. Your lawyer has ways to deal with that. And so don't get upset if you discover that the children are there and you never knew about it. Your lawyer has a lot that they can do, either to keep out the children entirely or make the other side look bad, that they can't make their case on their own. They have to bring the children there, or even have the judge talk to the children outside the courtroom. So the children could talk to the judge without the parents hearing, the good stuff and the bad stuff about each of the parents. So again, surprises like that do happen. There are lawyers who will bring the children to court every time, knowing that they're going to upset the other side. That's their strategy. They just don't really care if the judge thinks that that's a bad situation or a bad policy. So again, there's things that the lawyer can do. I typically ask, if the children are in court, what would the children say about you? What would the children say about the other parent? You told me you go to all of their soccer games. Do you really go to all their soccer games, or do you go to one a year? What are they really going to say? What type of things should I ask the children? If you coach the soccer team, we certainly want the judge to know that. If you live in another state, then you could testify. You keep up with their scores on the internet. You have photographs. The parent won't send you photographs of the soccer, so you had to contact the coach to get pictures of your kids, or you contacted other parents, or you went to the website for the team because the other parent wouldn't give you access. So the demeanor that you're kind of put together as a person, that's the message that you want the judge to get across, that you're the mature one, the other party is immature. The other party won't give you the name of the teachers, so therefore, to get the names, you contacted the principal, you contacted the guidance counselor, you contacted the school directly, you got the name of the teacher, wrote them an email, you introduced yourself. Here's the email I wrote. Now I'm on the school mailing list. I know what the children are studying. I get their assignments from the teacher that communicates it to all the parents. I had to do that myself because the other side wouldn't do it. So again, you've got a problem with the other parent. You want the judge to know that, but also you want the judge to know that you solve problems and that therefore you're the better parent. you're not going to come right out and say, I'm the better parent. But if you can have examples like that, where you have an immature parent on one side and you're the parent that rises above it, you're the parent that solves the problem. And again, you want to have the emails or the newsletter from the school that you had to get in spite of the other parent. So one of the factors on custody is, can the parents work together? And you can show, no, you can work, but the other parent blocks your access. So therefore, in that particular custody factor, you win. That is in your favor and is against the other parent. And can the parents work together for the benefit of the children? And if the mother is, or if the parent is blocking you from getting access to any information on the, the mother never told you who the child's doctor is. So you had to go and get it from the school, which has the medical records, and you got the doctor's name and address from the school records, and therefore you contacted the doctor's office, and now the doctor's office sends you information on the child. So the other side put a problem in your way and you solved the problem. And again, we would certainly want the judge to know all of that. Here's your record of asking the parent for the doctor information, no response or a string of obscenity. You contacted the school, you got the physical examination at the start of the year, you saw who the doctor was, you contacted the doctor's office, here's the email, here's the text message you sent to the doctor, and now here are the records that you've gotten from the doctor in spite of the other parent. And again, don't let the other parent set you off in the courtroom. You want to be calm. You want to show the judge that you've had problems with the other parent in the past and you've dealt with them in a calm manner. You didn't go over to the other parent's house and scream at them from the street until they called the police. So there's no police records. You dealt with this in a sensible manner. You have the proof. You have the email to the parent. You have the email to the school. You have the email to the doctor's office. 1, 2, 3. You're the better parent. Once the decision is made, behave yourself. Again, don't celebrate, don't cheer. By that time, your witnesses will have testified, and they're usually sitting in the courtroom behind you. Make sure they don't cheer or start yelling at the other side. There are more deputies than there are you. All right, the deputies always win. Unfortunately, I've seen it happen. You end up with supervised visitation, and your witnesses will reflect on you also. So it's not just how you should behave in the courtroom, but how your witnesses should behave in the courtroom. I mean, I've had witnesses that show up in nurses' scrubs because they have to. I mean, they're going right from the courthouse to the hospital. And that's kind of a good thing for a judge to see, these are your friends. These are the people that are responsible in life, successful in life. They don't absolutely have to wear a suit and tie or Sunday dress or whatever, but it should be appropriate. It should be clean. It should be well pressed. Appearances matter. First impressions are stay with you the longest and the strongest. So get a haircut, shave, don't wear obscene t-shirts. I've seen that. Party on, for a contested custody hearing is not a good idea. Like I said, if you have tattoos, if you have piercings, take them out, cover them up. At the judge's level, that's not something that is usually seen as appropriate. It is what it is. That's the world. So in general, you want to help your lawyer, talk to your lawyer. I always tell people, if possible, go there first. Unfortunately, a lot of times they've already been there a lot before they come to me. But, understand how the courthouse works, how the system works, so you don't get flustered because you can't find a parking space and now you're 10 minutes late and you got to go through security and you can't find the courtroom, and so on. Be aware, show up plenty of time, stay calm before, during, and after. Remember that everybody there is watching you. Even the courthouse people that have no involvement with your case, they're watching you. If you do something inappropriate, on the other side of the courtroom, they're down in the cafeteria, that'll get back to the judge or the judge's clerk. Everybody in the courtroom talks. Just, again, be aware. Behave yourself, act appropriately. You're the responsible parent, again, inside the courtroom, on the witness stand, and outside the courthouse, outside the courtroom. So, practice. You should get a lot of feedback from your lawyer, what to wear, how to act. Certainly you'd want to practice the questions, which should relax you a lot. You know, you're not the first client that'll have a history or a difficult past. You know, there's ways to deal with it. There's ways to make it seem less bad, and that's one of the job of the lawyer is to make that happen and make that possible. So I hope that helped. Again, this was just limited to, you know, how to act during a custody trial, and it's kind of my experience on, you know, things that work and things that don't work. And so I hope that helped a lot. So just to review, I'm Randall Borden. I practice law in Virginia and Maryland, and family law in the Washington, D.C. area. So I hope that helped, and I'd appreciate it if you could like this video. If you need my assistance, please give me a call. Thank you. Bye.